Hello everyone, good afternoon. Welcome to another episode of the Legal Matters podcast. Today we have the podcast in English and we are revisiting the topic of international arbitration. My guests today are Dr. Galina Zukova and my colleague Agis Georgiades. Galina and Agis, welcome to the Legal Matters podcast. Thank you for accepting the invitation.
Thank you for the invitation, Christopher.
So let me make a short introduction about my guests. Dr. Zukova is from Latvia, where she studied law. She has a PhD from the European University Institute of Florence, Italy, and an LLM from the University of Exeter. She's a visiting scholar at the Yale University, and she speaks 7 languages. She speaks English, French, Italian, Latvian, Russian, and Spanish. Don't you get confused, Galina, with... I always had this question. When you speak more than 2-3 languages, don't you mix them up?
Well, let's organize a separate section on this. I will be most pleased to participate in it. It's a good topic.
Okay. And Dr. Zukova is also a leading arbitration practitioner with 20 years of legal experience. I will post here the webpage of Galina so that everybody can go and see her CV if interested. Agis Georgiades is a very good friend. He's a Cypriot lawyer. He holds a law degree from the University of Leeds and an LLM from the London School of Economics, and he's also a barrister. Agis is also an accredited mediator and a fellow of the Charter Institute of Arbitrators. He's one of the best qualified Cypriot lawyers in international arbitration. He specializes in commercial and construction dispute resolution, and he's also a member of the teaching faculty of the law faculty of the University of Nicosia. I will also post Agis' CV under the notes in Facebook. And today we are going to talk about Delos dispute resolution. It is an international arbitration center, and my 2 colleagues are going to tell us about it. Agis, Delos is from a Greek word, isn't it?
Yes, I think it means what can be seen, and it's the sacred island of Apollo. But I may be wrong. I checked that a long time ago, but I may be wrong.
Yes, Galina, do you know what it means? Delos is a Greek word, I think.
Well, for me, it sounds extremely Greek, and I thought like this part will be taken care by Agis, right? But we have to, have a help of Delos people right now to explain to us. But it sounds, like the name itself, obviously, it evokes thoughts of Greece, and together with this, so how it was in ancient times, right? So there's like wisdom, like Greek philosophy of wisdom. So it kind of goes well with arbitration, right? And it's also in a lot of, there's books and publications about history of arbitration and, history, like how it was arbitration in ancient Greece, including, right? So I think when people were looking for a title, for a name of an institution, this was something on their mind and something what impacted them.
Absolutely, yeah. So, Galina, can you tell us a few words about Delos dispute resolution, like in 1-2 paragraphs, what it is and when was it founded and how it works?
Well, let's start with Delos is a very new institution, and it's a really very young institution in terms of age. I think they are maybe 8 years old. but also in terms of age of people who drive it, right? So the organizers, the driving force behind it are very young people with very good arbitration experience, with substantive arbitration experience. They were and they are, basically we're speaking about two people where, one of them was with a leading arbitration law firm, Deckard, for many years, in arbitration practice in Paris and then in Dubai, so he has a lot of practical experience. This is Hafez Ria, and then Thomas Granier, and Thomas, who's a French national. I had a pleasure to work with him before because we coincided at the International Court of, at the ICC, International Court of Arbitration. So we were colleagues. I was counsel in one of the teams, and he was deputy counsel. So, and Thomas, he stayed in arbitration. So he's a practical experience is approximately 12 years. So these are people who, young age. And they say, maybe there is something new what can be done in the arbitration market. And I appreciate that initiative. So they approached the idea, again, from a different angle, saying, okay, we have seen the ICC, Thomas was at the ICC, and then he worked for a leading law firm, working with major cases. The same thing for Hafez, once you work for Deckard, you work with big cases. But when you say arbitration, it's not only about these massive cases, right? Massive in terms of major cases, big amount of disputes. There are a lot of arbitrations about smaller disputes. And why not to set up something for smaller disputes? And I think France is a good market for that because there is no a good alternative for that, I would say, at least for international disputes. So they try to tackle this, to address this niche and to come up with, innovative ideas. So, and they do progress. So to their credit, there's a lot of progress. People know about Delos. People do podcasts about Delos. This is not the case with every institution, right? So they're definitely very good with BD.
Okay. If I can just clarify there that when Galina says smaller disputes, she means probably within the range of 2 to 15 million euros, because that is the bulk of cases going to arbitration. So for a small jurisdiction like Cyprus, these are not small disputes. They're considered to be significant disputes.
Absolutely, yeah.
But if you take into account that there are disputes at the ICC and the CIA of billions or hundreds of millions, then these are considered to be relatively small.
This is a good point, but I think I would a little bit disagree here, not strongly, but I wouldn't. Every institution can have a dispute up to 15 million. This is clear, it's just, whatever dispute comes to you. But I think the organizers of Delos, they're open, obviously, for any disputes. But they even started in before, there's a lot of consumer disputes. And consumer disputes, they're obviously not in millions, or they're not about millions, right? It may be about 2,000, 5,000, and maybe about 50,000. So I think there's also they look at this niche, which counts in thousands, be that 5,000, 50, 200, and more. I would,
So I guess. If I understand, first of all, let me say that I have posted the URL link of the website of Delos. It's delosdr.org, and there is a lot of information on the website about the institution and what it does. I guess, does it have a correspondence in each country? Because I saw from the website that for each country there is a law firm. How does it work, the organization?
Yes, actually, one of the best ideas that they've had was to have local reporters in, not in all jurisdictions, but in most jurisdictions, at least the jurisdictions that are important in the arbitration world. And they are trying to increase them every year. So what they do is they get information, local advice on what is the state of arbitration in that jurisdiction. And they publish the reports, but they also use that as they use the data to prepare their green light list, as they call it, or the safe seat list, meaning that you get a green light for every issue for which your jurisdiction is in an acceptable standard. And if you have all green lights, then you are considered to be, then you may be considered to be a safe seat. That, of course, depends on various issues which Delos processes. But it is a very, very important function, I think, because it is often the case that when we select a seat, or when we ask an institution to select a seat for us, that we do not have the information that we need in order to decide whether that seat is a good seat in general and suitable for the particular dispute. So it is a very, very special function of Delos.
Okay. Is Cyprus a safe seat?
It is, yes. It's all green lights. We do have some negatives, which you and I know very well. For example, the delays in court proceedings, which could cause delays in arbitrations. But yes, we have green light on all issues.
Let me make a parenthesis here. Galina, in Latvia, what is the average time for the adjudication of a civil case in your legal system?
You asked me a good question. I'm not practicing in Latvia for 20 years.
You're not?
I'm practicing from Paris. But,
in Paris, in France, I mean...
it goes into a few years, you know, like
few
it goes
years.
into a few years. Also because, I mean, we obviously have few instances, right? You have first instance, you have appeal instance. Sometimes you go even, you know, like to the Supreme Court, whatever, cassation, you know, like if it's France. So of course it can turn into several years. Arbitration without appeal, it is normally shorter. It is normally shorter, even for, you know, maybe not for, again, exceptionally big cases. Right? But it may take few months, and it may take 1.5 years, 2 years. You know, like I will make here a little bit parallel with the ICC, International Court of Arbitration, because you know, like obviously it's an institution which runs big dispute, and pursuant to their statistics, the average length of international arbitration proceedings is, you know, less than 2 years. Right. So I think this corresponds roughly what we see, you know, like for international cases, rather big ones, you need at least 1.5 years to do it all. For smaller cases, shorter.
So you have vast experience in international arbitration. And if I ask you, what is that distinguishes Delos dispute resolution from the other international arbitration center, would you be able to say 2 or 3 characteristics that make Delos distinct?
Well, it's an institution which grows, right? Which is now right at the stage of, you know, like, this is like when you are born and now you have to show, I can do it, you know, like and obviously when we speak about institution, you know, like there is institutional wall around the institution, but it's all about the people, you know, like, do you trust people who run this institution, right? It's about that, you know, like trust in the institution and the people who run the institution. So I think Delos right now is at this stage at establishing its reputation, getting the cases, because cases also don't come to you in 1 year after you have established the institution. Not at all. It's a long-term project. And this is what I like about these guys, because they are realistic about it. They know they can't have 50 cases next year, right? It's unrealistic. I think they come up with innovative ideas. And the latest rules, which they approved and released this year, there are some interesting features, you know, which show you the innovation challenge or the innovation mood, whatever. We're not afraid of these innovations. And maybe big arbitration world is a little bit more conservative than they are. And they probably, possibly will follow some of the innovations which Delos offers today. But we'll see how this will develop in the next years. But there are definitely some tricks in the rules which make you think.
Agis, could you identify some of the tricks? Or in your opinion, what distinguishes Delos from other institutions?
Well, okay, before going into details about the rules, some general issues. I mean, the Delos rules are quite small in length and simple, which is it is always something which is seen positively. However, they are very well drafted and concise. What the idea, I think, was to have a set of rules for all cases. Now, the tendency in most institutions worldwide is to have different sets of rules, rules for small claims, for expedited procedures. So they have different sets of rules depending on what the nature of the case is. What Delos does is that they have one set of rules which is can work with different categories of cases. And the primary way in which they distinguish cases is according to the subject matter. So if you have a small case, you are looking at a simpler procedure and a faster procedure. If as the case goes up the scale, procedure can be a bit more complicated and lengthier. So these are the general issues, I think. But then there are some very distinctive characteristics, as Galina said, which some of them are quite innovative, and I'm very keen to see how they will be accepted by the community and how they will work in practice.
So, Galina, one of these characteristics is the active role of the tribunal, isn't it? There is is there a different perception at the Delos as to what is the role of the tribunal and the level of intervention? What would you say on that?
Well, this is a good question. I think all institutions, they do speak actually about the active role of the arbitrators and of the arbitral tribunal. It's in my view, it's a little bit difficult topic, right? Because the efficiency of the proceedings does not depend only on the tribunal. It depends primarily, I would say, on the parties and then of the tribunal. So as long as we have a parties agreement on certain things, if the parties have agreed on a long time schedule, it's very difficult to say to a tribunal, let's shorten this timetable. Sometimes you may say, maybe we can have a hearing before. And I had this situation, some of my cases, when we would go to the first meeting with the parties, first Zoom meeting, nowadays it's all normal. And we would have certain ideas in our minds as members of a tribunal, how long this matter, where we see in the request and the answer, how long this matter may take. And then suddenly parties come up with longer procedure and we're like, okay, our parties in agreement, and both parties, obviously, we have discussed this already on the telephone. So it's very difficult to put then shorter deadlines, you see? So it's like you can be active, but there are limits to what you can do. So I think in this respect, this is not so much different from other institutions. What is in these rules, and when I was reading them, it's definitely what attracted my attention, is that before the tribunal renders the award, and I have to check which article it was, the tribunal with the parties agreement can actually give a non-binding version of of its decision to the parties, and then the parties may see whether they agree with it, and then basically go with kind of a settlement, right? it's a provocative provision. It's a very provocative provision, and it's very much depends on. I think, like, what is your legal background? What is your experience as to whether you accept this provision, whether you're comfortable as a tribunal with this provision or not. And if I'm speaking too long, Christopheros just cut me, don't be afraid. But we had recently, I'm a member of the ICC Commission on ADR, and there is now task force on arbitration and other ways of settlement of dispute. So the idea is to see how arbitration can be combined with other methods of dispute resolution, like mediation, I don't know, you name them, right? And in some, we had people from different backgrounds, and in some jurisdictions, some legal systems, it is accepted that the judge, and by default an arbitrator, can tell the parties its preliminary thoughts on the dispute and say, you know what, I actually think, you know, like, this party has right on this point and this party is wrong on this point. So most probably, like, my decision will go this way. So the idea was, like, why wouldn't it introduce it, like, on a, like, more international level? And people from our jurisdiction was saying, no, because here arbitrators don't have this function, you know, like, and as an arbitrator, I cannot say anything. I prejudge the dispute. I prejudge the decision.
It's impartiality.
It's a clash of legal cultures here, right? And I will be even more specific. You know, like, in Germany, this is basically an accepted practice. And again, I was looking at these German arbitration institution rules of arbitration. You know, like, I had a case with them recently, and where indeed the arbitrator can provide preliminary thoughts to the parties. You know, whereas this is not in my legal upbringing. I like, obviously it's cool, you know, like, I never did it, but also how I practice arbitration in different fora, I never saw it. So this is something foreign to me. I'm not that comfortable about it, right? So, but probably this point has a point in it, right? It's not a bad idea. But it's something we will see how this will develop into the future, right? But this is definitely calls for a hot debate. This point.
Agis, before you comment on this, our colleague Dr. Anna Plevri, she explains to us what Delos means. So Delos means apparent, and it is a Greek word from Dilumeno, and is the name of a Greek island. So both arbitration and Delos have Greek origin. So Anna, thank you very much. It's her name day tomorrow. So
Anna is always a lifesaver. Thank you, Anna.
Yes. So I guess, what is your take on this active tribunal thing, considering that the jurisdiction that we come from, the courts have to be impartial, not express an opinion, and not to go into the dispute?
Well, it was actually one of the things that we were discussing and disagreeing with Galina. So I'll try to give the data so that you can form your own opinion. I think that the common law world is moving away from the traditional adversarial model where the judge is passive. This is what I've seen in the CPR, the English CPR of 1998. This is what I see in the new CPR that will be introduced in Cyprus. And I think it is the tendency in international arbitration, even in purely common law tribunals, for arbitrators to have a more active role, meaning that they do not allow the parties to tailor the proceedings as they wish, but they do have a strong opinion often about issues and how they are to be resolved. And there is an increased efficiency resulting from this, I think. Just for people who are not into this, a simple exercise to see how different the perspectives are is to compare the IBA rules on the taking of evidence and the Prague rules. The former were they have been criticized as being largely the work of common law lawyers, whereas the Prague rules have been developed as an answer of the continental system. If one reads the two instruments, he or she will see that the differences are vast, totally different perceptions of what justice is and how justice should be served. Now, which one is better or worse? I mean, it's a matter of a very long, lengthy discussion. I will not comment on that. So, having seen this difference, I think I also see that there is a tendency for an abridgment, and from both sides. What most rules do, and this is where I disagree with Galina, is that they tend to not to prescribe active powers of the tribunals, but they rather leave it largely on the lex arbitri, the law applicable to the proceeding. And if that law allows a more active role of the tribunal, then that tribunal is free to take it. Whereas what the Delos rules do, which is different, is that they expressly state that the tribunal will have this active role and that it has certain powers, for example, to ask the parties to consider certain issues or to truncate deadlines for submissions or to make submissions, which are more close to the continental system, as I think. So that is a point of disagreement. But on the other hand, I think the ultimate question is, what does one mean by active? Because once we consider that, we may see that even on the definition of that term, people may have a very different idea about what it is.
Yeah, that's true. So it's certainly a matter that needs to be discussed, and it needs to be seen in practice how it works, of course, to see how it will be received by the community in general. Galina, another characteristic that caught my attention was this the mechanism for the settlement procedure, and that the way I understand it, the arbitration procedure can stop to enter into a settlement negotiation phase. So could you talk us a little bit about this? Even before arbitration starts, attempts to settle, or as I understand it, during the arbitration?
Well, I think, again, approach is similar across different jurisdictions here. Like settlement, like if we speak about disputes, it's normal to have some pauses to try to settle. Like I'm teaching arbitration, and I'm telling to my students, like in our family life, we always have disputes, it's just a matter how you solve them, So it's good sometimes to take a pause, and once there is, one thing is how you try to negotiate before the arbitration has started, before the request for arbitration has been filed. Because, okay, there is a threat, but there is nothing concrete. Once there is a request for arbitration, of course, another party would feel a little bit intimidated, right? And that party also, actually, the respondent can fight back very hard and submit major counterclaims, right? So, then also the leverage changes. So it's good then to see all the parties' position in writing. And at this point of time, or, maybe after first procedural meeting with the arbitral tribunal, maybe later, and so on. It's like stage can be very different. There is no rule. There's really no rule in this field. When the parties say to the tribunal, please put these proceedings in abeyance for a while because we are trying to have a settlement here. And, like normally the tribunal, of course, will accommodate this wish of the parties because this is what the parties want. This is for the better of everyone. And here also like proactive role of a tribunal, I link to your previous question. I think the question is also, should the tribunal sometimes tell to the parties, but you know what, why don't you put the dispute on pause and go and try to settle the disputes?
You mean the tribunal itself without being asked by the parties to do that?
Exactly. It's a very active role of a tribunal, of course, right? So does the tribunal? You see, you shake the hands, and this is the right reaction. And again, I was a little bit skeptical about this, but then I will tell you, it really depends on a case. It really depends on a case, because recently I was in a case. I was sitting as a co-arbitrator, and the president at a certain point of time told the parties, it wasn't like a major dispute. This was between rather small companies in Central Asia and China. And then we told the parties, but what we see, that you want to continue your business relationship, right? You still need those things which didn't arrive, but there is a possibility, like what we hear from you, there is a possibility to agree something, right? And we explained this to them. We said, like, okay, you have a dispute. There was even like more procedural complications. And we said, like, but why don't you speak? We don't want you, like, if we have to decide, we will decide. But listen to each other, because from outside it seems like there are joint, like common business interests. And then you come back to us. If we'll have to continue, we'll continue. If not, you may bring to us settlement agreement. We will make an award out of this. It will be enforceable, and so on and so forth. And the parties came back to us in 3 weeks' time and said, like, we settled. So, like, this was a clear example to me that sometimes it works, but it will very much depend on your feeling of the parties, on your feeling of the dispute. And I think this is a fine line for the tribunal not to cross the border, but it's not the same border for all cases. It really depends.
Yes, I see that there is a possibility, even after the proceedings are concluded, to have a settlement phase. Right. So how does this work, and what is your opinion generally on this pause for settlement idea?
Well, I think that any position that there is a right time for discussions for settlement for every case is dogmatic and completely wrong. The identifying the right time when such discussions can take place is a very, very difficult task, and there are many different theories on it, and there is a lot of literature on the subject. I think that what the rules potentially do here is that they give a learned tribunal the possibility to assist the parties to identify the right time for discussions. It is not just a matter of, it's a cultural thing. It depends on the nature of the dispute, the nature of the allegations. You can understand that if we have a dispute which involves issues of illegality or fraud or taking away the assets of a company between two former friends and mutual shareholders in a company, then they will be ready to attack each other at the beginning. It's a purely commercial dispute between parties that have an ongoing relationship, then it is very different. So it's also very different depending on what the culture is. The Chinese culture of settlement is a lot stronger than ours. So you need to appreciate all these things. So what the rules do is that they give a learned tribunal the power to advise in a way, or maybe advise is the wrong word, to assist the parties to find the right time and place it on the procedural timetable. So that can be at the beginning, it could be during the proceedings, maybe after the pleadings, or it could be after the award is reserved. And another issue here is that the rule works both ways, because a tribunal that is not learned could easily allow such proceedings to be abused by recalcitrant parties. So by prescribing this power in the rules, you are basically normalizing in the way this power so that it can be exercised with some prudence and within certain reasonable limits. So I find it to be a very useful tool, again. Very good idea.
Does it have? Does the tribunal impose a timeline, a time frame on the parties to find a settlement, or is it open-ended?
No, usually it's not open-ended. Usually, the tribunal would probably say something like, "We have a cutoff date for submissions," meaning that there will be no further submissions from that date. And before we call you in, so that we start organizing the hearing, we will have a settlement attempt. Sometimes it's called a cooling-off period. Which will last for 1 or 2 or 3 months, so that you can meet and discuss and hopefully find the settlement of the case. But this is just one scenario. It could be anything, basically.
Galina, procedurally wise, can you explain us in simple terms how the procedure begins? I mean, both parties have to submit to the and adopt the Delos rules, and then how does it work? Do they apply to Delos to appoint an arbitrator?
All right. I think the procedure is classical in some respect, and again, innovative in some other respects. As in court proceedings, as in any other kind of dispute, like there is a claimant, there is a respondent, so the party who initiates the dispute submits some sort of a document. Here we don't call it a request for arbitration. I think it is called notice. And when respondent comes with its notice of defense, I think this is the terminology. So a priori, it's the same as in any national court.
The language?
I think before they advertise themselves like they could work in 4 languages, and now they say basically in most of the languages. But again, I would say it's not a huge deal, because again, if we speak about international things, I mean, it's mostly English. When Delos is in France, is like French, right? So I mean, it's not like we don't even speak about Greek or Turkish, because there's big community who speak this language, but these are not small languages. So this is, I would say, language is not an issue. What is interesting, what I noticed, Delos, and this maybe also links with the complexity of cases they are trying to attract and they target. What they do at the end, and this is their annexes. This is something unusual, because first few appendices with a model notice of arbitration, model notice of response to arbitration. Normally, rules of arbitration of institutions, they don't provide for this model request, model notice of arbitration. They decided to go this way, and probably it also makes sense from their business perspective, because again, there are some very well-educated, high-caliber counsel in international arbitration. But since the practice of arbitration is growing, and it's always growing, there are a lot of newcomers who don't know, how to draft the document. So for them, this document can be this model notice of arbitration can be of help. Or if we speak about consumer disputes, you know, like again, consumer for consumer, you know, like to hire a lawyer, this is obviously a big expense, you know, like, so why not to go with this model? So this is something unusual. Another thing which, again, if I understood it correctly, but which is unusual for me, which is not traditional and classical, Delos rules say, so there is a notice of arbitration by claimant, there is a notice of response, whatever it is called, by the respondent, and then the parties will nominate their co-arbitrators, if this is a three-member arbitral tribunal.
Okay.
Normally, how it is done, the claimant submits request for arbitration and puts on his name, right? And then when the respondent receives the request for arbitration, a respondent already sees who is the arbitrator nominated by the claimant. So here, the constitution of a tribunal is postponed somewhat.
Okay.
So it's you know, like, it's also a valid proposal. I would not necessarily dispute with it. And what is interesting, I think, like from the arbitrator's perspective, that we, you know, like we know who our counsel, you know, like normally by the stage, we know who our counsel, not only to the claimant, but also to the respondent.
Okay.
So when I agree, you know, like it's like, okay, I'm available, I'm available to take this matter, that you are not in the dark who are the respondent's counsel. So this is one of the things which just come to my mind like this. So this is a little bit unusual way of how to constitute the tribunal, but again, innovative. We'll see how this will work in practice. But it has positive moments to it.
Agis, is there a procedure for obtaining ex parte remedy or interim orders in this in the rules?
Yes, there is an express provision for that in the new rules, which is can be a very useful mechanism. Of course, when we are talking about measures, we need to remember that in arbitration we lack the coercive powers that exist in state courts. Whether that makes it less likely to be enforced is a big issue to discuss, because even if you have let's say that you have court proceedings and you issue an injunction against a person not to do something. You issue that injunction in Cyprus and that person is a resident in Moscow. Again, I mean, unless that person travels to Cyprus.
It's not possible to enforce it.
It's not possible to enforce it. And with that in mind, and taking into account that in most international arbitration disputes, parties are located in different jurisdictions and coercive powers cannot easily touch upon them anyway, it may not make much of a difference. It will make a difference in simple measures, for example, when freezing a bank account or prohibition of selling real estate, for example, because you know very well that you can actually enforce that judgment by going to the land registry or to the bank, whereas an arbitration award cannot do that. But I think it is a power which is useful. It is very often complied with voluntarily by the parties, and it is also a deterrent for parties to act unreasonably, for example, to destroy evidence or to move around assets when they should be doing that.
Yes, but still, Galina, the issue of enforcement is a huge one, isn't it, in arbitration, because you do not have the power that courts have and the repercussions from not following a court order, isn't it?
Well, you know, like it's all about enforceable awards. It's all about enforceable awards, you know, like, because what we are trying to sell in this area, be your counsel or arbitrator or institution, this is if a party does not comply with the decision voluntarily, this decision will be, and it's possible to enforce it. So of course it's all about compliance and enforceability. You know, like I wouldn't say like it's only about enforceability, because again, if we look at the data, and there is no one single set of statistics, like about the compliance with arbitral awards. It's impossible to have this kind of statistics because arbitration is confidential. Like there's like some institutional arbitration. Like not all institutions publish statistics. Then there is ad hoc arbitration. So we don't have, like a clear idea, like how many awards are out there and how many are complied with and how many are not. But there is a good compilation, or attempt to kind of get some statistics, and this was done by Lucas Mistel and Stavros Bricolakis from the Mary Queen College in London. And they look at the, they ask users of arbitration, how it works in practice. And in practice, in most kind of cases, like in almost 90% of cases, there is a voluntary compliance with the arbitral award.
Yes.
So the system works. The system works. It's not a perfect system, but it works very well. It works very well. So the question of enforceability, it's about like the remaining 10%, like when there is no voluntary compliance, how to enforce those awards. And then we come back to this safe seats seats of arbitration from one side, and then heavens for keeping your assets, right? And how to get access to your assets.
I guess, if I am not mistaken, in the new rules, there is this compliance enforcement mechanism in Article 16.
Yes, that's also an innovation of the new rules, which is...
yes, can you tell us what this is? Very briefly.
It basically, usually when an arbitration leads to a final award, then the arbitration institution doesn't really have anything to do with the dispute, with the issue anymore. What Delos are trying to do here is they're trying to follow up to see if there has been a compliance with the award.
Okay.
And if there has not been a compliance, then the Delos will decide on whether to publish the fact of non-compliance on their side. Of course, that's not done always. It's they have a discretion, and they will listen to the parties before they do that, because there may be some very valid reasons why the award has not been complied with. But I think the idea behind it is that if a party to an arbitration, an unsuccessful party, refuses to comply with an award with no good reason, then having this published it has some adverse consequences on that party, and it may assist in pushing that party to compliance. So that's the idea, I think.
Yeah. I will say for our viewers that the rules are posted on the website. I've gone through them very briefly, and they are relatively straightforward, I would say, in comparison with the rules of procedure of other international institutions. I will post here the link on Facebook of the rules so that everybody can see them. Galina, the final topic I want to touch upon is that of the costs. So in terms of costs, and compared with other international arbitration institutions, does Delos offer an advantage? Is it cheaper? Is it more cost efficient? I see in the rules that there is an appendix and we have a scale system depending on the level of the claim. So what is your comment on that?
Well, of course, we are competing against many other institutions, right? The competition becomes, like more and more fierce. I looked at the scale. It seems to be cheaper than let's say, like major international centers. They perhaps compete with some other regional centers. So I would say, it's cheaper. It's obviously cheaper than ICC or Stockholm or London, Vienna, etc. but they do compete with other centers, which is also normal, right? Interestingly, there is a FOC, like the minimum and maximum, like it's not unusual. And then there is also a time limit within which what has to be rendered. And again, it's a good attempt, like to keep arbitration under control, like cost together with arbitration under control, because if there is a time limit on everyone, it's it has its positive effects. But then again, we have to be realistic. How always it is possible to keep complied with the time limit.
Of course, the time limit is indicative, as I understand it, right? It's not.
It's in all systems. It's indicative. In basically all systems, the institution, like very often, the institution says like, this is our time limit, but it can be extended. So the institution, board, the court, like whatever it's called, council, retains the right to extend this time limit. Yes.
So for a claim, Agis, between 50 to 200,000 euros, there is an arbitration cost beginning at 4,400 euros. I guess this is the filing fee for filing the case, or is the overall cost?
No, that's the overall cost is that amount plus a percentage of the amount in dispute. That's how it is calculated.
Okay.
But in a case, in a significant arbitration case, the cost of the tribunal is not always the major concern of the parties.
Yes, this is what I was going to ask you. What about the cost of the lawyers? That's a separate thing, isn't it?
Well, yes, of course. It depends on what you get. I mean, I've been in a case where the team for the claimants was 27 people. So you can imagine what the cost of that case was.
Okay.
Some of them very, very senior lawyers. But that's not an ordinary case. But if you have rules that allow fast procedures, simple procedures, then that will inevitably lessen the lawyer's cost as well.
Yes.
So from that point of view, I think that Delos are making a decent effort to minimize cost, in the sense that the tribunal's costs and the institution's costs are, as Galina said, quite cheap compared to the major institutions and comparable to other regional institutions. But the ability that they give to the tribunal to make the procedure simpler and faster means that the client may end up paying less in general. So that's a good thing about them.
Yeah, and these fees are paid in advance, right? Yes, I suppose. In order for the case to start.
Yes, and if the respondent is not willing to pay his shares, the claimant may be asked to pay the full share himself. So that could be a huge issue.
Okay. So, Galina, have you been involved in Delos dispute resolution cases as an arbitrator or as a counsel?
Not yet. I will be honest, not yet. But again, as I said, the institution is relatively new. So if you are 8 years old, it's unreasonable to expect a big caseload in such a short period of time. But I know they already had few references to that. So it has taken off. Yeah.
Yes. Agis, you?
Me neither. Same with Galina. I'm trying to follow their developments. I haven't had a case with them yet, but I think that the way things are progressing, sooner or later we will have some experience on that.
Okay, so I think we have covered the main topics. We have said what it is and made a reasonably good presentation to anybody that is interested, by way of introduction, of course. The website is very good. and I would invite anyone that is interested in this to have a look on the website and the model articles and clauses that are available there, the model agreements. The rules are very simple and straightforward. So I would give from 1 minute to each of you to make your final remark, and we will close the discussion, starting from Galina. Galina, are you in Latvia now or in France?
No, I'm in France. I'm based permanently in Paris.
Okay.
Well, my final remark will be on a question which you asked to Agis, actually. I think the innovation, for me, the main innovation they came up with is this compliance reinforcement mechanism.
Okay.
Right? And this possibility that, provided requirements are met and the requirements are set in the annex, there's a possibility to publish information about that one of the parties does not comply with the award. I think this is something new, something very, very strong and very courageous proposal. It's very much about transparency of arbitration. We speak nowadays a lot about transparency, but this is, it goes further. And probably, big institutions, they still did not address it from this point of view.
Okay.
But I wouldn't exclude that not in 1 or 2 years' time, but in 5, maybe 10 years' time, maybe 15, 20 even, we'll be speaking of something similar also with the big leading international institutions, where we want to have this information about how the parties comply with the awards. We want this information accessible. So I think this is, for me, the main takeaway from this revision of the Delos rules.
Okay. Yes, in Cyprus, of course, in the last couple of years, we are trying to encourage our colleagues to be interested about arbitration more in view of the problems that we have in the court system. So I would like your remark on that as well. Where do you think where are we going? Do you feel encouraged by the responsiveness of Cypriot lawyers towards arbitration?
Well, I'm naturally optimistic, so I'm hoping that it will go well. I think that there is a lot more interest in arbitration and ADR now than there was like 10 or 15 years ago. I think that what people do not appreciate is that arbitration, international arbitration, requires discipline and focus. It is not something that it is easy to do if it involves like 5 or 10% of your work time. It is something that you do full time or most of the time of your work.
Okay.
Otherwise, it's not easy to follow the developments throughout the work. But I see that I see more and more colleagues which are very well learned on the subject, dealing with cases in the last few years. And I think that we're doing quite well in developing it in Cyprus. Now, just to say something about Delos, if I may. There are many initiatives worldwide. Delos appears to be doing things right, and that's why we're discussing it right now. What started as a discussion over a drink a few years ago, when the founders were saying that we will set up an arbitration institution, and that was seen with some hesitation by many of us, is now working. Delos has purchased property in London. They are setting up an arbitration center. They have disputes. So for people who are interested in this field, it is worth to follow the developments with Delos, even if they do not use it. It is important to follow that.
Okay.
And if I may abuse my time, just also say thank you to you and thank you to Galina. Galina is a person that I know for more than 10 years. I know her since her time at the ICC. And is a very important personality in international arbitration, very well known worldwide.
You are too generous, but it's a pleasure. We haven't seen each other for 2 years in person, and we're just missing meeting an hour. But Christopher, I will keep Agis to his words, because he said once he will organize Cyprus Arbitration Conference during the Opera Festival in Cyprus, right? So this is when I will come.
Okay.
With big pleasure. But thank you for the invitation.
It was my pleasure, guys. Thank you so much. And Galina, for meeting you and having this discussion. Of course, Agis, I meet him from time to time because we eat at the same restaurant near the office, so we have more interaction. So thank you everyone for tuning in and listening to this podcast. It will be available tomorrow on all social media, and you can download it from YouTube, Facebook, or LinkedIn. I will be with you tomorrow with a discussion about corruption, another hot topic in Cyprus, Galina, corruption. We are struggling with it. So
in many jurisdictions, it is a hot potato.
We will talk about this tomorrow. So thank you, everyone. Have a nice evening and see you soon. Bye-bye, guys. Thank you so much.
Thank you. Thank you. Goodbye.
Bye.
Thank you.
Bye.